Good afternoon, everyone. This is Stephanie from Community Legal Centres Queensland. Welcome to today's webinar. The topic of today's webinar is a review of recent Queensland appeal cases relating to domestic violence protection orders. And I welcome you to the webinar. We acknowledge the traditional owners of the land. Here in Brisbane, that's the Turrbal and the Yagara people. We pay our respects to elders past, present and emerging, and we acknowledge the important role of Aboriginal and Torres Strait Islanders continue to play in our society. As this presentation is being viewed throughout Queensland, we also pay respect to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians listening to this presentation. We also acknowledge the disproportionately high rates of domestic violence experienced by Aboriginal and Torres Strait Islander peoples and the additional challenges this creates in us responding to this issue. This webinar is the last of our series, Building Capacity in Domestic Violence for Community Legal Centres. This webinar and this series has been funded by the Queensland Department of Justice and the Attorney-General through Victim Assist Queensland's Victim Services Building Capacity program. We thank them for their support. This series of webinars has been developed with the assistance of Community Legal Centre Queensland's Domestic Violence Working Group, and we thank them and you, our listeners, who have shown by your attendance amazing support for this series of webinars. Before I introduce today's presenter, please take a moment to read the important information on this next slide and visit our Keep Safe webinar page at any time. At the end of this presentation, there will be time for questions. If you have a question, you can send it through any time by typing it into the dashboard chat box on the right-hand side of your screen. To begin this presentation, I introduce Seraphina Noble. Seraphina is a Brisbane barrister practicing across a range of areas, including domestic violence. Thanks for being with us, Seraphina.
Thank you for having me. So the aim of this webinar is to summarise the procedural requirements for appeals in relation to protection orders, together with recent case law, and I've listed there the cases that I'll be talking about. And of course, the focus will be on practical points for advising or representing clients in these appeals. So if we look at section 164 of the Domestic and Family Violence Protection Act 2012, which I'll be referring to as the Act for the purposes of this webinar, we can see that the person who may appeal is a person aggrieved by any of the following decisions: a decision to make a domestic violence order, a decision to vary or refuse to vary an order, a decision to refuse to make a protection order, or a decision to refuse to make the protection order, the temporary protection order. Just one moment. Section 169 outlines the powers of the appellate court, and in deciding the appeal, the appellate court has the power to confirm the decision appealed against, vary the decision appealed against, set aside that decision and substitute it for another one, or set aside the decision appealed against and remit the matter to the court that made the decision. The appellate powers of the court, provided by section 169, are exercised for the correction of error in fact or law by the primary decision maker. And the general position is that the appellate court ought not interfere with a decision unless it is affected by an error of principle, there has been a failure to appreciate a salient feature, or there is otherwise a miscarriage of justice. And that was outlined in MDE and MLG at paragraph 80. The hearing procedure is as follows. It's usually decided by a rehearing on the evidence and proceedings before the original court. However, the appellate court can order that the appeal be heard afresh, in whole or in part. And that's outlined in section 168 of the Act. Where the decision under appeal involves the exercise of discretion, House and the King error will need to be shown. And I've copied and pasted an extract from that case. And once you read it, you'll see that the main questions are: has there been some error of principle? Has the judge allowed extraneous or irrelevant matters to guide or affect the decision? Have the facts been mistaken? Has the judge not taken some material consideration into account? Or, if specific error is not shown, is the result of the order unreasonable or plainly unjust? An appellate court must be very conscious of the limits of an appeal, because they are disadvantaged in respect of the evaluation of witnesses and the feeling of the case, and they don't have the advantage of receiving and considering the entirety of the evidence over a longer period of time. And that's stated in this case, Fox and Percy. And again, I've just copied and pasted the relevant extract. There's only one right of appeal from the Magistrates Court to the District Court, and you can see that in section 169(2), where the legislature says the decision of the Appellate Court upon an appeal shall be final and conclusive. And in this case, ZXA and Commissioner of Police, it was attempted to appeal the decision of the District Court by a provision in the District Court of Queensland Act, which allows a party to appeal to the Court of Appeal with the court's leave. But the Court of Appeal in that case found that that provision in the District Court Act didn't apply to this protection order appeal under section 169(1) of the Act. As for the costs of the appeal, when we look at section 157, we can see that each party must bear their own costs unless an application was malicious, deliberately false, frivolous, or vexatious, in which case the court may award costs against that party. However, the appeal provisions in the Act are silent about costs. In RCK and MK, Judge Morzone was of the view that that section was just limited to the primary proceeding and not the appeal. I've set out section 142 here, which says that when it says that the UCPR rules apply to the appeal. And so Judge Morzone was of the view those usual cost provisions in the UCPR applied to appeals. And he further noted that Section 15 of the Civil Proceedings Act empowered a court to award costs in all proceedings unless otherwise provided. There was also a case called BAK and Gallagher and another, 2018 Queensland District Court 132, where Judge Muir held in an application for costs of an appeal under the Act that the UCPR does apply in respect of appeal costs. So that seems to be the settled position. Though a judge may take the view that Section 169 does not give power to an appellate court to award the costs of an appeal, particularly where a successful appellant is unrepresented. There's a case I've put here that is HMG and BRC, which was under the repealed Act, which allowed district court judges the power to order costs of an appeal. And Dorney DCJ held that although he had that power, because the successful appellant was not represented or appeared, no order as to costs of the appeal were made. So we turn to our first case, RC and MM. This was an appeal of a 2-year protection order which named the aggrieved, her husband, children, and even her unborn child. The primary issue in this case was whether the magistrate had erred in concluding that an act of domestic violence had occurred, but predominantly whether the magistrate had erred in finding the order necessary or desirable. There were other issues, such as whether the magistrate was impartial and had erred in finding the applicant had discharged her onus of proof in circumstances where she had not challenged the respondent's evidence, and whether the magistrate had actually made an unsafe or unsatisfactory decision. The facts of that case were that Miss R, who was the aggrieved and the respondent to the appeal, was married with 2 children. She separated from her husband and met Mr. M, who was an old friend. They had an intimate relationship which ended after about 2.5 months because she was reconciling with her husband. And from that point in time, she contended that Mr. M was pursuing and annoying her, which was distressing. And the magistrate commented that it could be rising to the level of stalking. There was an email that was particularly contentious. He sent her and her husband an email sometime after the relationship had ceased. The email dealt with mostly unexceptional topics, such as offers to meet and discuss outstanding matters such as financial issues, but it attached a photograph of Miss R and Mr. M having sexual intercourse with some body parts blurred. And it also referred to the potential of a video being in existence, which the magistrate viewed as a veiled threat. In cross-examination, Miss R did agree that the email was really just the appellant seeking answers from her. Most importantly, Miss R and Mr. M had no children together, no shared bank accounts, and they each gave evidence that they had no desire for contact in the future. Before I talk about the findings on appeal, I'll just quickly tell you about the decision below. So Her Honour found the appellant by his email wanted ongoing conversation, and Her Honour referred to the nude photographs and the veiled threat with respect to a video. And it was ultimately found that the email was an act of domestic abuse. And she used the words domestic abuse, not violence, and so that it was meant to cause offence and emotional and psychological upset between the parties. There was no explicit analysis in her reasons as to whether the protection order was necessary or desirable, and the protection order was granted. So on appeal, it was found that the magistrate's reasons didn't analyse the question of whether the protection order was necessary or desirable at all in circumstances where the sworn evidence showed there was no ongoing relationship between the parties, and that this made it very difficult to see how there was any future risk of violence, which would give rise to a need for protection in the future. The magistrate, it was found, had erred in exercising the discretion by acting upon a wrong principle. She had not turned her mind to the necessary or desirable element. She had allowed erroneous or irrelevant matters to be taken into account. There was an unjustified conclusion that at the date of hearing, Mr. M wanted ongoing conversation, but in fact that email was sent 6 months back and there had been no abusive behaviour since then. There was also the fact that Her Honour had erred in not taking into account material considerations, and those material considerations were the uncontested evidence that there was no ongoing relationship. And I think in the trial there was an implication that Mr. M was only behaving since the temporary order, because of the temporary order, but that was not in fact put to him in cross-examination. So the appeal was allowed and the orders below were set aside and the application was dismissed. CPD and IVAMI is my second case, and it was an appeal of a 5-year protection order which named the aggrieved and the children of the relationship. The primary issue was similarly whether the magistrate had erred in finding the order necessary or desirable to protect the appellant's ex-wife and the children of the relationship. It was also an issue as to whether the magistrate had erred in finding that subsequent communication by the appellant's mother and the conduct of the trial by his counsel were further acts of domestic violence. In this case, Miss B was the aggrieved and the respondent to the appeal. She was also a police prosecutor. She had been married to Mr. C, the appellant, who was a former detective, and they had had 2 children. Miss B accused Mr. C of controlling, emotionally abusive, and threatening behaviour towards her during the breakdown of their marriage. There was an incident where Miss B was filling out a rental form and Mr. C tried to remove it from her. And amongst other things, there was a scuffle and the form was ripped apart. A temporary order was granted in respect of that incident, and later there were 3 breach charges of the temporary protection order. Mr. C was acquitted of all but 1, and the result was an absolute discharge with no conviction recorded. That breach charge was contacting Miss B on FaceTime to ask a question about a medication dosage for their son. And importantly, there was this undertaking that Mr. C would contact Miss B through email by his mother, and the mother acted as conduit between the parties. In the decision below, there was a lot of acrimony and confusion, and this was commented on by the appeal court. But the magistrate made findings. The first was that the emails from Mr. C's mother to Miss B contained negative input from Mr. C, and it contained from time to time unnecessary comments which were critical of her, and that constituted a continuation of harassment and offensive conduct. The magistrate also found that there was an overzealous and unsubstantiated attack on the aggrieved in her personal capacity throughout the conduct of the trial by counsel on the other side, which is unusual, and that was a prolongation of bullying through harassment and intimidation. She characterised that as an act of domestic violence. When I just said that there was overzealous and unsubstantiated attack on the aggrieved personally, it was to do with her also in her professional capacity as a police prosecutor. So there were all these allegations that she was using her position to better herself in the course of these proceedings. And there was a 7-month delay between the end of the hearing and the magistrate's decision. And there was no evidence about the nature of the relationship between that time. The findings on appeal were as follows. The magistrate's finding that the appellant was behind the tone and wording of the emails was found by the appellate court to be pure speculation. And the volume and content of those emails should have been seen in the context of exchanges dealing with mainly logistics over a relatively long period of time. However, the judge did note the emails contained unnecessary and unhelpful comments on both sides between Miss B and Mr. C's mother. The magistrate's findings and reasoning about Mr. C's knowledge of what was being sent by his mother was difficult for the appeal court to reconcile, and it was said that her findings were not open on the evidence. It was open, however, to infer that the reason the mother continued sending the emails was to comply with the magistrate's court undertaking. The consequence to the appellant of a finding that he was behind the emails required a high level of satisfaction, and there is no suggestion that the magistrate gave any weight to all of the considerations about the Briginshaw standard and that high level of satisfaction. Now, the conduct of the trial, it was said by the appellate court, so the actions of counsel, especially in cross-examination, may be relevant to matters such as costs, but the finding that the conduct of the trial by counsel constituted domestic violence was said to be inconsistent with the nature of the relationship between counsel and client. The conduct of a trial may not only be a product of instructions, but also of advice. And it was said that the conduct of the trial was largely a product of the style of the counsel, and it was noted that that counsel had argued with the magistrate on numerous occasions, and that shouldn't affect the trial. And because counsel can take their own course and exercise their own discretion in how to tactically handle a matter, that shouldn't have been taken to be indicative of anything on the respondent's part by the magistrate. And robust cross-examination in exercising curial rights as counsel should not be characterised as an act of domestic violence. The magistrate didn't take into account any of the evidence about how the relationship had transpired between the hearing and the decision, and that was a period of 7 months. And the appellate court found that would have been relevant, very relevant to the question of whether a protection order was necessary and desirable and ought to have been received. It was also said by the appellate court that the magistrate considered extraneous or irrelevant matters, and that those were the conduct of the trial by counsel and the communication from the mother as being acts of domestic violence, and failed to take into account the relevant matter, which was the nature of the relationship in those 7 months between the end of the hearing and the decision, which was also particularly relevant given that the mother was no longer acting as conduit. Finally, it was found that the children should not have been included in the order because there was no suggestion they were privy to any acts since November 2015, and the prospect of them witnessing any domestic violence in the future was very unlikely given they no longer lived together. So the appeal was allowed and the order was set aside, and the matter was remitted back to the magistrate's court for rehearing. The appellate judge found it inappropriate for him to substitute his decision because there were so many credit findings made by the magistrate, who is clearly in a better position than him to observe the witnesses, and because of the finding that the magistrate ought to have received and considered the state of the affairs since the hearing, which in another rehearing could be considered. My third case is called RCK and MK, and it was about an appeal of a 5-year protection order. The issues in this case were whether the magistrate had erred in making the order and not adjourning the application and finding sufficient evidence to justify there was domestic violence or that the order was necessary or desirable. In this case, the appellant, Mr. R, was the nephew of the respondent, aggrieved Miss K. There were two events. The first was a violent assault by the nephew's father on the aggrieved, after which the nephew, the appellant, Mr. R, threatened Miss K and ran off and then drove off. The second incident was at a later date. The appellant, Mr. R, had made a gesture in the form of a pistol and pointed to the aggrieved whilst they were both in separate cars at traffic lights. There were other related applications and criminal proceedings involving the assailant in the first event. And because these proceedings were related, this one was adjourned until the outcome of the other, and the matter returned to court, and the notice of adjournment addressed to the respondent personally identified the time of the hearing. And when the matter finally came on, the clerk indicated there were no persons present for the respondent, having apparently called for his appearance. The aggrieved also did not appear due to work commitments and gave instructions to the duty lawyer to act on her behalf. And during the course of this hearing, no one attempted to contact the respondent's representative, and arguments followed. It was argued that the nephew, Mr. R, was present at the assault and encouraged his father, the assailant in that assault, and threatened the aggrieved with the pistol gesture. And this was elevated from the previous position, which was that Mr. R had simply watched as his father assaulted the aggrieved. And there were also very broad allegations about the family and the conduct, which was not otherwise particularised. The magistrate gave short reasons in support of a 5-year protection order, having regard to the matters outlined by the representative of the aggrieved and the terms of the order that were made in a related matter. There is no express guidance as to the considerations involved in deciding whether to hear and decide the application or to adjourn the application pursuant to Section 39 of the Act, which I've copied and pasted here. So Section 39 is about when the respondent does not appear. And if they fail to appear, the court may hear and decide the application in the absence of the respondent, adjourn the application, whether or not it has made a temporary protection order, or issue a warrant. The absence of the aggrieved was not a matter which would have prevented the magistrate from proceeding to a hearing. And There was a case that was referred to in this appeal judgment called BLJ and QLB, which I'll talk about a bit later, which refers to natural justice and affording a hearing. But continuing on, there was no positive explanation for the absence of the respondent or his solicitor in this case, despite the notice being addressed personally. And the appeal court found the only rational inference was that it was a mere oversight. The appeal court found a list of things which should have been taken into account but weren't. And those matters were that the proceeding was subject to active management with other related proceedings, in particular the criminal proceeding, which had not yet been determined. And it had been previously determined between the parties as common ground that those cognate proceedings should be finalised. And in the hearing, the subject hearing, it was acknowledged by the aggrieved's representative that that prerequisite had not yet been met. So that criminal proceeding had not been determined, and there was no courteous attempt by the representative of the aggrieved to contact the solicitor for the respondent, and especially in the context that that representative changed the hearing from a mention to seeking final orders, and particularly where the state of the evidence was the subject of express dispute. Ultimately, it was found by the appellate court that the magistrate had not taken into account material considerations in exercising the discretion to proceed or to grant an adjournment, and misdirected herself in proceeding to hearing and making those final orders, the result of which were found to be unreasonable, unjust, and a failure to properly exercise the discretion. So the appeal was allowed and the orders were set aside and the matter returned to be reheard. Notwithstanding all of those findings, the appeal judge went on to talk about the sufficiency of evidence which would justify the making of the order. Judge Morzone noted that the Magistrates' Court was of course not bound by the rules of evidence, and the requirement is that it is satisfied on the balance of probabilities. He gave he stated that though the Magistrates' Court is not bound by the rules of evidence, it's a well-settled principle that the court's decision must arrive from relevant, reliable, and rationally probative evidence that tends logically to show the existence or non-existence of the facts in issue. And that in this case, the matters about the respondent's conduct was in the category of suspicion or speculation, which ought properly be subject to a hearing. The evidence as it stood fell well short to justify the making of a protection order. And it was said that the other proceedings, the related ones, resulted in considerations of irrelevant matters which affected the magistrate. So we'll move on to my fourth case, NBE and PRT. Now this was an appeal where the application for the protection order was dismissed in the absence of the applicant, and on the basis that it engaged section 157 subsection 2, enabling the recovery of costs against her, which is an exception to the usual position. So those were the issues. There was a side issue because the notice of appeal was filed late, about a week late, by the applicant, and the argument on the other side was that the district court didn't have jurisdiction for that appeal, considering that it was filed late. So I'll just go on to the next slide. Section 165 subsection 5 allows the district court to extend the period for filing, and that is at any time. The judgment went on to talk about the principles whether that discretion should be applied, and they were whether there was a good reason for delay and whether it would be in the interests of justice to grant the extension. And in this case, there was in this case, there was no explanation for the applicant's delay of 1 week, except a lack of understanding and difficulties encountered because she was self-represented. The applicant was only seeking the intervention of the district court concerning the costs order against her. And it was said in the appeal that this was not ordinarily allowed by section 164. However, the costs order that had been granted against her was exceptional. The magistrate in the decision below had awarded the cost order for various reasons. He thought that the fact that the applicant had filed in Hervey Bay as opposed to Western Australia, where I think the parties lived or had family court proceedings, had forced the respondent to incur substantial costs. He also had regard to her decision not to attend the hearing, despite being informed by the registry that it was necessary to appear personally. He also had regard to her emails to the registry. One of those emails, she advised that she wished to withdraw her application due to the cost. He had regard to the conduct of the applicant in posting for financial assistance in the electronic media online, and he was of the view that that was a deliberate attempt to get money from unsuspecting members of the public under false pretenses. It was found by the Appellate Court that the magistrate had depended upon unchallenged evidence put before the court and without any notice to the applicant or opportunity for her to respond. And where there is a finding of malice or deliberate untruth, It was a very high burden, and the magistrate did not analyse any of those relevant principles. And particularly in the absence of an applicant, those findings would need to be based on much more objectively, categorically established foundations. As to the costs issue, we look at section 157, subsection 2, where the court may award costs against a party who makes an application that the court hears and decides to dismiss on the grounds that the application is malicious, false, frivolous, or vexatious. It was said in the appeal that costs pursuant to that subsection should have a very cautious approach, especially in the absence of the party against whom the order is sought. And a party seeking the exercise of such power should expect to justify the conclusion as a clear one and from an objective point of view. It should have been a matter of showing the application was misconceived or lacked legal foundation. Moreover, for costs, the respondent needed to show her application had no foundation, and the appellate court found this was not so in the context of there being a previous temporary protection order and an undertaking, and there was no clear and objective indication of the application being frivolous. It was also said that the magistrate entered error and did not take into account section 147, subsection 1, that the aggrieved may be represented by a legal officer, police officer, or authorised person in circumstances where she actually had a justice of the peace outside the courtroom to represent her, and this was refused by the magistrate. It was found that the magistrate had erred in preemptively dismissing the entitlement of the justice of the peace to appear for the applicant, who she had expressly authorised in correspondence for him to so appear. Though the magistrate would not have been bound to allow him to represent the applicant, that issue was never appropriately considered. And the appeal court found that the applicant's written materials were largely given little or no consideration and allowed them to be swept aside by quite contentious evidence of the respondent. And there was significant misunderstanding as to the applicant's preparedness to pursue her application and have the JP pursue it for her in determining the question for costs. So in those circumstances of substantial error, the applicant was granted an extension of time for filing her notice of appeal, and the cost order against her was deleted. The last case I've got here is BLJ and QLB, and I just wanted to briefly run through the points about natural justice, which I previously referred to. This case was predominantly about whether the magistrate had denied the appellant procedural fairness, and it otherwise erred in finding there was an act of domestic violence and that the protection order was necessary or desirable. So when referring to those principles, it's good to read these two paragraphs that I've copied and pasted here. and they're there so you can refer back to them. And then a further 2 paragraphs from that decision is on this slide as well, which is useful for submissions about procedural fairness. Ultimately, the appellant's affidavit provided a reasonable explanation for his failure to be heard, and Judge Rosengren found that the appellant's misunderstanding was understandable, and he had promptly brought that to the attention of the court soon after he learnt that the orders had been made. On the affidavit of his, it was found that he had an arguable case and that the rehearing of the matter may well produce a materially different result. Judge Rosengren also had regard to the fact that there was no apparent prejudice to the first respondent if the interim orders were to remain in place pending the determination of the hearing in relation to the final orders. And there was also, in the appeal, the appellant sought to produce fresh evidence, and Judge Rosengren was of the view that fresh evidence could be received in exceptional circumstances where the interests of justice unequivocally demanded it. And to that extent, receiving the affidavit for the limited purpose of determining whether the appellant had a material argument, the appeal was heard afresh. That brings me to the end of my presentation.
Thanks very much, Seraphina. Perfect timing as well. If anyone has any questions, I don't think any have come through as yet. Would you like to type them into the box onto the right-hand side of the screen? I realise this is one of those presentations where there's a lot of information to take in, so questions might not immediately come to you. If you have questions afterwards on considering the material, feel free to email them through to me. I'll pass them on to Seraphina, and I'm sure she'll help out if she can. One thing that struck me when we were going through that, Seraphina, was that almost all of the appeals were brought by respondents to protection orders. Do you think that indicates anything other than these are the people who feel strongly enough about a matter to push it to appeal or have the most riding on an outcome?
Possibly. Yes, it did occur to me as well when I was looking through the material.
And I think in advising people about prospects on appeal, perhaps we tend to err on the side of caution and explain the difficulties in a successful appeal, which may, advisedly or not, put some people off pursuing appeals, do you think?
Yes, quite possibly. Yes.
It's a difficult matter for Community Legal Centre staff and volunteers to advise on appeals because you don't have usually the time to go through all of the material that's relevant. So I think we tend to just give people some very quick information on what's involved in bringing an appeal, and that probably doesn't inspire them with confidence about their prospects a lot of the time. I don't see any questions come through as yet, so please take up my offer to email them through afterwards if you would like, but we will wrap up for this afternoon. In the coming weeks, we'll be loading onto our website some resources which we have developed from this series of webinars. We'll forward those links and information to you. If you have any questions about those materials, please let me know. I'm sorry, a question has just come through. We'll just see if we can quickly answer this in the time that we've got available. It's in relation to that case RCK and MK. At first instance, the question is, how far does the aggrieved solicitor's role to contact the respondent's lawyer go? So this is the one where both the lawyer and the respondent didn't appear, despite having, it sounded like correspondence from the court addressed to them. What's the onus on the aggrieved solicitor in that situation to try and notify them? Normally you'd just go outside the court and at least make a phone call, I would have thought, would you?
Yes. And that was just considered by the judge as something that ought to have been done. Nothing more than probably a phone call would be expected.
I know it's times have changed in the conduct of all litigation, including these matters, but that kind of thing I think would normally have been considered common courtesy, where you would call your opponent the day before a matter to see whether there's any extra material or any prospects of settling, and certainly if they didn't turn up on the day, you'd just contact them to see what had gone wrong, if anything.
Yes, absolutely.
But sometimes in protection order matters, it's not clear who the lawyer is because notice of address for service don't have to be filed. People do change counsel at the last moment, so it might not have been as straightforward as that in that case.
In this case, it was known who the lawyer was because they'd appeared at a previous mention.
Right.
So that's why it was expected.
Yeah, it's a difficult one, but I think going back to perhaps your ethical obligations to the court and the profession, perhaps a courtesy call at least might be expected. But if the magistrate didn't give time for a matter to be stood down for that to happen, I suppose no criticism could be attached to the lawyer in that situation. But given the opportunity, I think that's what you'd be wanting to do, wouldn't you?
Yes.
Yeah.
Yes.
Thank you very much for that question and for your attendance today. We will wrap up now. Feel free to send through any other last questions after today, and I will now end the webinar. Thank you, everyone.